Hello everyone, you're all very welcome to today's Trinity Business Alumni webinar. My name is Michael Malooly and I'm part of the Alumni Relations team here at Trinity Development and Alumni. Today's webinar is being provided by corporate sponsor Mason Hayes & Curran LLP, and I want to thank them for being with us here today. Today's webinar will last approximately 1 hour, including some time at the end for questions from the audience. So just a few technical issues before we get started. I would like to quickly show our attendees how they can toggle exiting and entering full screen mode at the very top right of the screen. And as well, you can adjust your audio settings in the bottom left of the screen. If you ever need to leave the session at any point, you can do so by clicking the Leave Meeting button at the bottom right of your screen. And finally, we encourage you all to ask questions that you may have throughout today's webinar as they come to you, and you can find the Q&A button to do so at the bottom of your screen. If you experience any technical issues during this webinar or need to drop off at any time, we will be recording it and sharing it with the TBA community later on in the week. And now I'd like to briefly introduce our three speakers for today. William Dillon Leach is a partner in the corporate M&A department at Mason Hayes & Curran LLP. His practice includes mergers and acquisitions, IPOs, advisory work, venture capital, joint ventures, and corporate reorganizations across the energy and natural resources, pharmaceutical, technology, finance, aviation, and real estate sectors. Judith Reardon is a partner in the restructuring and insolvency department at Mason Hayes & Curran LLP and primarily advises on insolvency and financial restructuring matters, together with all related litigation. And finally, Ronnie Neville is a partner in the employment, law and benefits team at Mason Hayes & Curran LLP, advising a broad range of domestic and international clients on both contentious and non-contentious matters. Judith, Ronnie and William, I'd like to thank you all for being with us here today, and I will hand the mic over to William.
Thanks very much, Michael. Good morning, everyone, and thanks very much for joining us today. My name is William Dillon Leach, corporate partner in Mason Hayes & Curran, and I'm joined by Judith, and my restructuring and solvency partner, and Ronnie, my employment law and benefits partner today. So, following the reopening of many, but clearly not all sectors of the economy since lockdown, and with parts of the country now operating at differing levels of localized restrictions as part of the government's new plan for living with COVID-19, the current environment does present unprecedented challenges for businesses to open, stay open, and keep employees safe. Many businesses operating in a reduced capacity or reduced revenues will have to carefully consider if the business does in fact remain viable and how reduced revenues can impact on cash flows and the ability to pay creditors. Decisions are going to be based on certain presumptions and projections that businesses will return to some level of normality within a particular time frame. And I don't think any of us have the crystal ball gazing ability to figure out when that will be. And I think we think certainly into 2021. But for now, we'll take you through some of the main legal considerations that directors or managers of businesses will need to keep front of their minds when trading in the current environment. We'll also examine how businesses can facilitate a safe return to work for staff, and we'll discuss some of the main issues that our employment law team is facing in this trading environment. We'd like to make this session as interactive as possible, so as Michael said, we're adopting a Q&A format, and you'll notice the Q&A function on your screen, so please do enter questions as we go along, and we'll try and answer as many questions as we can towards the end. So Ronnie, I might begin with you. In the context of those businesses that have recommenced operations since lockdown, what do you think are the most important issues that directors or owners of businesses should be considering from an employment law perspective with your employment lawyer's hat on?
Thanks, William, and hello everyone. Good afternoon. Just to clarify, in case you think it's like a pre-recorded version of the toy show. Good afternoon. Thanks very much to Trinity for inviting us to participate. I think that that as the months have gone on, the predominant focus was initially after the emerging from lockdown was on health and safety. Many business owners, effectively, many of them became quasi health and safety experts in their own right. So for those businesses that have a few months under the belt already, I think that the systems and the processes are pretty well embedded. And the issues therefore are the practical conundrums that we're going to be touching on now. Issues last month like return to school, and recently the reverting to, or the moving to level 3 on the government living with COVID plan. But for those businesses that are just getting back to reopening, or reopening more fully, I think the number one priority simply has to be health and safety considerations. It's a process that has to be owned by directors, and I know it sounds like management speak and managing it from the top down, but really given the risks and the issues involved, it's something which directors and owners need to take real ownership of, as opposed to delegating many of the other functions that they would otherwise delegate to managers, for instance. There's a ton of materials available to businesses to equip themselves in preparing for this sort of health and safety focus before you even look at the employment law issues. The government website, the gov.ie, there's a document called the Return to Work Safely Protocol. We're treating that a bit effectively like a Bible in the context of setting out the roadmap for the do's and don'ts, or what's legally required of businesses in the context of health and safety obligations. There's great stuff on the health and safety website. There's great guidelines, sector-specific guidelines on the Fáilte Ireland website. They've got specific guidelines for like 10 or 12 sectors, including pubs and hotels and restaurants, cafes, tourism, spas. But ultimately, I think that from a health and safety perspective, the businesses need to be looking at a couple of core things to prioritize, and that is having a COVID-specific risk assessment. You can't rely on your previous risk assessment. We're looking at a new business setting, obviously, with all that COVID brings. It's not going to be a one-size-fits-all, so what works for a small business isn't going to work for a bigger business, and vice versa. It's not just the physical workspace in terms of the risk assessment. You got to look at travel to work, entrance and access. What kind of protocols you're going to develop for when you meet someone on the stairs, in the canteen, in the toilets, in the conference rooms. It's going to involve issues around sanitation, air handling, water, hand sanitizers. How do you manage disposal, all physical distancing, all of these issues, and there's a huge raft of them. But again, there's a huge amount of source material to help you. I think that's really the priority. It's more health and safety than pure employment.
Okay, thanks, Ronnie. That's really helpful to hear that. And I think it would be really interesting for TBA members to understand or to hear about day to day, like obviously since April, what are the main issues that you're advising on? What are people asking you from an employment law perspective? What issues are they bringing to you for advice on?
Yeah, well, they're quite novel. It's different. What we've been hearing from hearing from clients and advising clients on, it's just so many different practical questions around how to actually manage this return to work. It's not a question of employees' attitude or not having the correct attitude. It's just these practical conundrums. Like when you're going back into a phased return, what's it going to look like? How are you going to manage? How are you going to select between staff members in relation to who's coming back and when? You got to look at who can work remotely in accordance with government guidelines and who can't work remotely. And then those practical issues, you're looking at practical parents issues, individuals issues, transport issues, childcare issues, disabilities issues, those who are carers, those who have mental health issues, or even just not mental health disability necessarily, but anxiety, concerns, issues around how you're going to split teams, to avoid cross-contamination. Can you look at flexible hours and how you're going to manage that? I think that the key thing from an employment law perspective is engagement, staff engagement and consultation. In Mason Hayes, for instance, they carried out a survey, and I think that's a really practical, it's a good tip from a practical perspective as part of your consultation with staff, is to look at carrying out a survey in relation to what people want and what their needs are.
Okay, thanks, Ronnie. And Judith, maybe turning to you, as an insolvency practitioner and restructuring practitioner, like from your perspective, Can you outline the main issues that directors should be considering when they're trading in this very difficult trading, the current economic position, the current trading environment, very, very strained. What should they be considering?
Yeah, thanks, and good morning, everyone. I mean, it is undoubtedly the most challenging trading environment that I've ever experienced during my career. But unfortunately, a key issue that directors need to be aware of is the fact that trading while insolvent and incurring debts that won't be paid, it does present high risk for directors. Therefore, so at the moment, I think the absolute focus must be on cash flow management. I think it's fair to say that different issues are going to arise for businesses that were closed for a number of months, or perhaps even that remain closed now, compared to a business that was able to operate at some level of reduced capacity. I think, obviously, as we touched on earlier, to compound it, we've now got the increased lockdowns, and I think there's going to be a continuing level of uncertainty as to when we're going to be coming in and out of the different levels. So, like, a number of clients have already told me that they just about made it through the first lockdown, but a second lockdown will be fatal to the survival of the business. I think it's also worth flagging that a business that had financial difficulties prior to the pandemic will probably have different and perhaps more difficult decisions to make than a business that is only affected by the pandemic. But either way, every business has to be able to pay its debts as they fall due. So for that reason, I'd say that it's absolutely critical that all businesses need a plan that shows that it will become cash flow positive in the short to medium term. Obviously, every plan needs to be based on reasonable but very thorough analysis of the financial position that the company finds itself in, and problems just shouldn't be ignored. That said, forecasts and projections, they don't have to be overly conservative. They just need to be realistic. To take a simple example, if a business is currently operating at 50% capacity and it's got perhaps increased costs because of increased sanitation requirements, but it's got the same fixed costs, it's really going to have to consider how it is going to maintain its cash flow if it can't renegotiate the fixed costs, for example, be it rent or something like that. I suppose without being too gloomy, I would also recommend that any plan includes adequate contingencies for increased trading restrictions, as I think just the level of uncertainty at the moment remains an issue for all businesses.
Okay, Judith. So clearly, you need to be on top of the financial position of the company, and you should have a plan in place. But in order to formulate that plan, what are the kind of the key data points? What's the key financial information that you need to have to hand really to focus on implementing this plan on a day-to-day basis? What are the information points that we really need to be looking at?
Okay, so I suppose just to follow on from the point I'm making about cash flow, to ensure that directors meet their duties and responsibilities as a director, I think it's really important, particularly at the moment, that up-to-date and accurate financial information is available, probably on a weekly basis. Obviously, this is going to be very dependent on the nature of the business and the size of the business. But I think the directors need to be aware of the up-to-date cash flow position and the likely cash flow position for probably the next 6 to 10 weeks at least, if at all possible. Again, without being gloomy or overly pessimistic, I think it's incumbent on the directors to make sure that the projections include the impact of further lockdowns, if in any individual business's case it will impact cash flow. I think slightly more broadly, then directors also need to have all of the information available to them to know how much is owed to the business, because obviously other businesses are affected and may not be able to discharge amounts that are due to your business. Who owes that money? How likely are they going to be able to pay in the foreseeable future? Again, where relevant, what's the value of the stock? What's the creditworthiness of customers? And what's the position with key suppliers? Are they also adversely affected and not able to supply goods at the level required, or be able to increase deliveries in due course if that's required? I think it's also very important that directors are aware of all loan contracts with lenders. What are the obligations and the default provisions in relation to those? Contracts with customers and suppliers, insurance policies, because it's really important that there's a clear understanding of the company's obligations under all of those contracts. And so that, to the extent that there are liabilities that might arise, and that the projections can include compliance with any of those contractual liabilities. I suppose, to sum up, as I've said, incurring debts that won't be paid is very risky for directors. So I would just say that directors have to have all relevant information available to know the current financial position and if or when the company or the business may run out of cash, so that, you know, if in that eventuality, prompt and informed decisions can be taken when needed.
Okay. And Ronnie, maybe one for you. Look, from an employment law perspective, where do you see the main areas of exposure for liability, both for businesses themselves and for the directors of those businesses, in terms of how they conduct themselves, having, you know, potentially reopened their businesses or maybe implemented some sort of a return to the workplace?
I think businesses and directors owe duties to three main groups of people. And I think they're the same three groups of people that pose the greatest risk to the business at this time, which is COVID. I think they're the employees, they're the customers, and they're the third-party contractors or suppliers. And I think if you look at the main risk then associated with those three groups and the primary risk for business, certainly from an employment perspective, as opposed to the insolvency issues in terms of trading that Judith is describing, I think it's all COVID related. And I think if there's an outbreak that's associated with your business, I think you're looking at, you know, potentially personal injury claims, potentially the risk of a health and safety prosecution, because I mentioned the protocol document earlier, which is, you know, it's a mandatory document, and many of these provisions under health and safety legislation give rise to offences in the event that there's a breach. And then, of course, there's the court of popular opinion. We've seen so many recent, you know, it'd be laughable if it wasn't so serious, between Golfgate and other examples of breaches of regulations. And I think businesses are going to be way more cognizant of the potential PR damage in the court of popular opinion in the event that they're shown to have, you know, not done all that they should be doing in the context of risk mitigation. I think it's important then to check your insurance, check with your broker to the extent that it's possible, get some sort of approval or confirmation that you're doing the right things, that your insurance is in place. If you get it wrong, it's not just it's not just the directors who are the officers. You know, most provisions under a raft of legislation, employment, health and safety, and corporate, most of these acts which provide for potential offences also include the potential for not just directors, but also for other people. If an offence has been authorised or consented to, or is attributable to the connivance or neglect on the part of some other manager or similar person who's acting in that capacity, so, you know, they could also be guilty of that offence. So I think it's a cause for reflection for a lot of non-director managers who should also know that they've got a vested interest in making sure that these risks are avoided.
Okay. And Judith, so just turning to the issue of cash flow and looking at that list of creditors, it may be useful for a company to pay you know, one creditor while, you know, treating another creditor as almost a historic one or not that useful. How risky is it from a director's perspective to, let's say, as we term it in the legal world, prefer one creditor over another?
Yeah, and look, it's a very live issue that any business that has insufficient cash to pay everyone will have to deal with. The starting point is always going to be that paying one creditor in preference to another is going to be risky. And as I've said, if a company can't meet all of its debts as they fall due, then no creditor really should be paid without very careful consideration. But that being said, and particularly in the current environment, if it's the case that paying the useful creditor can reasonably be expected to, you know, ensure the survival of the business or result in a better overall position for the creditor body as a whole, and this is really important, it's done in the reasonable belief that the company's financial position can, you know, return to good health, then it may be okay to make the payment. You know, taking the example, a key supplier, you know, that delivers food to a restaurant on a day-to-day basis may have to be paid because the alternative is to cease trading immediately. So taking the restaurant example, if a builder has remained unpaid for work done to refit the premises to meet social distancing requirements, the decision may have to be made. Either we pay the food suppliers and we don't pay the builder for the time being, because otherwise we have to close the business. But as I've said, the directors have to be satisfied that ultimately the builder will be paid in that situation. And in an ideal world, and I would recommend this, that there is open dialogue with any party that will remain unpaid for a certain period of time, because really what you want is an agreement with revised credit terms, and also you want to avoid any distraction from running the business by threats of litigation or threats of winding up proceedings or any kind of pressure being exerted by a creditor to get paid. I would say as well that if the board is making any of these kinds of decisions, that the rationale for them should be documented, because, you know, in due course, if anyone is looking back at any of these decisions, it is important that directors are able to explain why one party was paid and another party was not paid. Again, if it's a very significant payment, or if there's, you know, any kind of uncertainty amongst the board members as to what should be done, it may be appropriate to take legal action prior to making the decision, or sorry, legal advice, excuse me, prior to making the decision.
Okay, so you referenced there earlier, you know, creditors exerting pressure. What if a creditor is extremely aggressive, really looking for payment and exerting a lot of pressure, you know, for you to make that payment? Is it okay then to sanction the payment to discharge of that liability, or how is it seen?
Yeah, so the courts have made it clear in a number of decisions over the years that if a creditor is applying overriding pressure, a payment can be made. But that's really okay. It's the same analysis as I touched on earlier. It's really only okay where the directors believe that the company can survive and ultimately that all liabilities can be paid, because effectively the decision that you're making by paying the creditor that is exerting a lot of pressure is a decision to say, if we don't deal with this creditor, the business will have to go into some kind of insolvent liquidation or some other problematic issue for the company, such that the payment needs to be made. But if the directors believe that the position is hopeless, that making any payment in that respect is very risky. And, you know, it may be the case that if such a payment can't be made, it brings the decision point to more serious decisions regarding the survival of the business.
Mm-hmm. And so obviously, Judith, you know, businesses are stretched at the moment, and they need to meet their liabilities as they fall due. What about if a company is looking for needs to get additional loan facilities or some sort of an overdraft, and a bank or other party is willing to advance that to them, and it's not sure whether, you know, the trading position is that they'll be in a position to repay that? What would your advice be in that circumstance?
Yeah, so I suppose it's a bit of a running theme through all of these answers and the decision-making points for the directors. But, you know, if you can honestly form the view that, you know, a new loan facility will ensure the survival of the company and that the loan repayments can be made, then of course it's reasonable to avail of credit. But I suppose it brings the plan back into very sharp focus, such that you need to be able to project out the company's or the business's ability to meet these repayments based on the projections and the cash flow and so on that I touched on earlier. So again, I would also say that any decision to avail of additional credit, be it an overdraft, a short-term overdraft, or, you know, a longer-term loan, that any decision around that should be documented really carefully, and it should also reflect the basis on which the decision is made on the company's repayment ability.
Ronnie, just turning to you, obviously more recently, you know, the government advice, particularly in Dublin, is where employees can work from home, that they're advised they should work from home. But, you know, some employees, some businesses can't operate remotely, and, you know, some employers do need to bring employees back to work. What if an employee can't or won't come back to work? What can an employer do then to manage that process? To either make the employee feel safe to return to work, or otherwise, you know, just invite the employee back to work?
Yeah, we've seen lots of queries with employees who are fearful of coming back to work, either, you know, using public transport or who are engaged in customer or client-facing roles. I think it's important for the employer to bear in mind that the current government guidance is to prioritise working from home or from home. So employers have to look at that even more carefully, or even if they've looked at it before, if it's feasible to do it, you really need to try to prioritize that first off. So let's assume that they've looked at that and decided that unfortunately it's not feasible given the nature of the role or the nature of the business in question. There's a difference between those who don't want to come back versus those who can't come back due to some medical condition. If you deal with the first category first, those who are fearful of returning to work, so there's no medical disability or vulnerability, but they're really cautious, genuinely fearful of using public transport, dealing with customers, and that's, regardless of the employer's efforts or measures that have been taken in order to comply with COVID regulations. First, you have to engage with the employee, see if you can address their concerns. You should be explaining that you're complying with all the guidelines and the restrictions the government has put in place. It may require a bit more detail with the employee, more than you have to with other staff or more than perhaps you want to. But, this is a reasonable step for an employer to take in order to allay what are legitimate concerns. In addition, there could be ways for the employer to work with the employee in relation to getting them back. Can you introduce temporary changes to their terms? Changes their working hours, for instance, so they're not traveling at peak times at the beginning or at the beginning or the end of the day. Maybe because of the reduced numbers coming into the business, there's greater availability of car parking spaces that might be afforded to that employee on an exceptional basis. But if you assume you've exhausted all reasonable measures and engaged and tried to assuage those concerns, once you've done all that, then I think you can take a pretty robust stance with employees who are still refusing to come back to work, in accordance with their contract of employment, and that could end up resulting in either disciplinary issues or potentially not being paid.
So, we've dealt with the won't or the can't, and they're the category of kind of reluctant employees and what we could do about them potentially. But what if you have a medically vulnerable employee and they don't particularly want to return to work? What should we be thinking about them?
I think it's different if they're medically vulnerable. The HSE has two different risk statuses. You're either extremely vulnerable or you're in high risk. And the distinction primarily relates to your age or to the individual's health. The current advice for those who are extremely vulnerable is if they can't work from home, it is advisable and under the guidance for the employer to get occupational health advice. In other words, bring in an external advisor or specialist in order to see, whether this vulnerable person can work from the office and potentially with what measure is being adopted to enable that person from working from the office. If you're in a high risk category, the advice is, again, to work from home if possible. But if you can't work from home, then it's up to the employer to try to arrange for social distancing to maintain 2 meters apart from others at work. There's going to be an overlap between, this vulnerability that we're talking about in the context of COVID and also disability, which is a defined term under Irish equality legislation. And it's really important for employers to acknowledge and to remember the legal obligation under equality legislation to provide reasonable accommodation to employees who have a disability under equality legislation. And this means engaging with employees to see what measures can be taken to assist the employee to continue to work. And if that means, even incurring some cost, but it means doing alternative duties at home or doing alternative duties in work or a mix or changing working hours or changing the structure or layout of a station or duties to some extent. These are issues which absolutely have to be looked at by an employer before deciding, okay, because of your vulnerability, that now with your disability means that you're unable to provide work. I think, first and foremost, bring in the occupational health specialist or the medical advice. Ultimately, it depends on that specialist advice because you as the employer can't make those calls. Engaging with the employee is key, like I've mentioned a few times already. And if, in fact, there's a medical certificate confirming that they shouldn't be attending at work, then they're going to be on certified sick leave. But if they are not certified as being unable to work, or the doctor suggests that because of the nature of the condition that they're not fit for work because of the unavailability of, or the impracticality of putting in place measures, then I mean ultimately they're not medically certified, and therefore they should be coming in to do work based on whatever measures have been taken by the employer. And if they refuse to do so, now again you move into the harder position, which could result in potentially strong language being used in terms of coming back to work, potentially disciplinary, or just not paying staff. Where there isn't that medical cert, they are fit for work, but they're moving back into the won't rather than the can't.
Okay, thanks, Ronnie. Judith, just maybe a question for you. We've been talking about managing cash flow in an increasingly difficult trading environment, but people may not ordinarily know or realize that trading while insolvent can attract personal liability for directors of a company. What do you normally advise directors on in this context to help them mitigate against that risk of being personally liable for the debts, or in some way being liable with their director's hat on?
Yeah, so I mean, I feel like I've been talking about crystal balls since March, but the fact remains that nobody has a crystal ball and nobody knows how this ultimately plays out at this point in time. And I think it's fair to say that not every business failure results in personal liability for directors. But that being said, directors do have responsibilities and duties. And as I've said, the plan that the directors are basing the business decisions on need to be based on projections. But again, these may or may not prove to be accurate depending on how all of this plays out. So I think in order for a director to try to avoid personal liability in the event that any of these projections are wrong, is to ensure that all of the financial information is accurate, as I've said, that all of the decisions and the reasons for them are documented, and that all of the projections are realistic. And it's also really important to remember that business decisions have to be made at a point in time. And, the courts have, very frequently said that, actions of directors aren't viewed through the prism of hindsight when decisions ultimately turn out to be wrong. That said, on the flip side, if it is clear that from the financial analysis, that the company is insolvent or on the brink of insolvency, and there isn't really any realistic prospect of being able to trade out of the difficulties, it may be the case then that the only option is insolvent liquidation. And, delaying that decision where it is inevitable can present risk for directors. It's important to remember that where the company is insolvent, that the director's duties shift to from acting in the best interest of the company to acting in the best interest of the creditors as a whole. And, again, decisions have to be made, but anything that is done which worsens the position of creditors, it does present more risk for directors. And it's not an automatic personal liability or anything close to it, but it does increase the risk. Obviously, insolvent liquidation is a worst case scenario, and I would always say that the various restructuring options should be considered before deciding on a terminal insolvency process. So again, going back to the plan and the projections and so on, I would highly recommend that the various restructuring options are included in any plan at an early stage, so that if plan A fails or something beyond your control arises, that there's time to implement any restructuring, so that no drastic decisions have to be made without having considered the alternatives.
Okay, and I think when people hear the word insolvency, they may conflate that with the term liquidation. And, liquidation, end of the road, and that's it. But you mentioned restructuring. So, and I know this is probably quite a wide term, but, what are the other less drastic terms under this heading, restructuring that may be available to people if they want to avoid that end of the road position, the liquidation?
Yeah, look, insolvent liquidation is definitely the worst case scenario, and all other options should be considered if possible. But as I've said, without delaying liquidation if it's inevitable, as you've mentioned there, restructuring is somewhat of an umbrella term, and captures everything from agreeing, revised terms with your bank on your loan facility to, a formal court supervised rescue process and everything in between. So I would say that a business that's facing financial difficulties, due to the absolute uncertainty in terms of the trading position, it's worth considering, if the business could survive if it, renegotiated or avoided the obligation to pay debts in full, be it with trade creditors or other creditors, if it closed a portion of the business, either temporarily or permanently, reduced its product line or service offering, renegotiated leases that are priced above current market rate. Obviously, that's a massive burden for many businesses. And, unfortunately, the consideration may have to be given to making some staff redundant. I would say any of these restructuring options in an ideal world would be achieved through negotiation. But it's also worth exploring if any of the more formal rescue processes could be used, which can very effectively deal with, legacy debt or onerous contracts such as leases. I think it should always be kept at the forefront of consideration that restructuring probably needs to be done quickly, because if the cash has run out, it may be too late. So I would also say that, it's incumbent on directors and managers to know, what liabilities are going to be problematic, what creditors may be obstructive if they are approached to agree revised terms or reduced payments. I think it's also really important to consider whether all or part of the business is viable. So part of it's viable, should the attention move to that part of the business, and what options are available in order to achieve any of that. So, I think all of these factors will feed in and influence which options might be viable to ensure the survival of the business. For example, a few years ago, we opted for a chain of pubs that had invested really heavily in its food offering, which wasn't successful through no fault of management or otherwise. But through a restructure, it was possible for the unprofitable portion of the business to be closed, leaving the profitable portion to continue trading, and all of management's focus then could be directed towards the profitable portion of the business. And that was achieved through a restructure.
Okay, but if the, I suppose if the cash runs out, if you are coming to that end point, and you do realize that your financial difficulties are probably going to be insurmountable, how quickly do you need to act? What do you need to do? And what should directors be taking action on?
Yeah, look, in short, very quickly. As I've said, if it's clear that the company's insolvent or on the brink of insolvency, and there's no realistic prospect of being able to trade out of the difficulties, the directors have to act in the interest of the creditors instead of the shareholders at that point in time. So, sometimes that will mean ceasing trading immediately and preserving the assets and value in the business and going into insolvent liquidation, sometimes within a matter of days, depending on the nature of the business.
Okay. And maybe just turning to you, Ronnie, look, obviously the news has not been good over the past number of weeks. That there's a new government plan. That we're hearing the R factor and numbers rising in the news reports at the end of every day, which is obviously a concern for everyone. But from the employer's perspective, if you're trying to encourage people to come back to work in that environment, and if they can't remain at home, and if your business can't operate without your employees turning up to work the physical workspace, can you do things like test temperatures in order to keep your all staff safe, amongst the other measures you've identified? This idea of temperature testing at the entrance, can you do that as an employer?
Like so many aspects of this COVID pandemic, when you're asking whether it's an insolvency question or an employment question, a lot of the answers that we're giving are very much tailored to this particular pandemic, and we find ourselves answering in a way which we would generally never envisage answering. So normally we'd have serious concerns, less so from an employment perspective, more so from a data privacy perspective around temperature testing. I mean, obviously it goes to the heart of the issue of, reasonableness and proportionality, and because it is quite an excessive and potentially invasive measure being adopted, and particularly because it's dealing with not just your personal data, but it's sensitive personal data, which for anyone who has endured the whole GDPR change in the last couple of years, we all know now that there's much heightened and greater responsibilities on the employer and on parties generally who are processing sensitive personal data to have express consent and also to treat it way more carefully than your regular data. So with that little long-winded preamble, I think the answer is a qualified yes. It's interesting that in the earlier months of the pandemic, I think it was around March or maybe April heading into early May, there was a particular query raised of government in relation to whether temperature testing might be a feasible option to be used. And the response from government, which hasn't changed since then, was that if and when it's advisable or advised by public health. Now, there hasn't been any public health guidance on it. Similarly, the Data Protection Commissioner has already looked at this and has confirmed that when measures are taken in response to coronavirus, and when those measures involve personal data, including health data, then it needs to be necessary and proportionate. So those decisions have to be informed by guidance and public health. And again, there hasn't been public health. So it's almost like there's a qualified yes and approval from the Data Protection Commission or Commissioner. But I think that, you'd have to look carefully at it. Ideally, dispose of that data immediately that the information comes through. You don't want to be retaining it for too long. And in terms of proportionality, I think you have to watch this space in relation to how long you'd retain those measures in place as being a response, a reasonable response by the employer. So at the moment, I think it's a qualified yes.
Okay, and obviously, absent the temperature testing point, can employers insist that employees be medically certified to return to work, or at least complete some sort of a health declaration, or where maybe employers can survey employees as to whether or not they're fit to return to work, and are there any kind of point us to any legal considerations around that?
Yeah, so taking them in reverse order as to whether you can develop some list of questions. I referred earlier to what I was sort of jokingly referring to the Bible for all businesses that are reopening. And anyone who's got kids, or anyone who has people going to sports, returning into sports, or indeed under this protocol document, the return to work protocol, returning to work, to the physical infrastructure of work. There's a specific list of questions that are legally required to be answered of any body that's organizing a return to sport, to play, and in the work setting, return to work. So it's not just a question of whether the employer can develop a list of questions. The employer has to develop a list of questions. Now, if they want to expand upon that list with their own questions, now that brings back into play the whole issue of proportionality, and there'd be data protection issues to be looked at. But certainly it is appropriate and indeed a legal requirement for an employer to have a checklist, which an employee ticks the box and signs in the bottom saying, I confirm that there are questions like, I haven't been sick, someone in my family hasn't been sick, and I haven't been in the company of folks who have been sick. Basic questions like that. In relation to whether you could have someone medically certified as being fit to return to work, I think that it might be different if it was a standalone request that you present an employee and say, I want you to go and get this cert. That'd be quite unusual. But if someone has been off sick, and they're off sick with a cold or a flu, and now we're heading into flu season, and anyone again in kids, one of my children has a sniffle and a bit of a cough, and now you're going, okay, well now everything gets escalated into this really heavy mandatory COVID regime, which is quite worrying. But if someone has been off sick, I think it's a reasonable response by an employer to say that, particularly if they've already been giving sick certs, doctor's certificates, it's not unreasonable for the employer to say, by the way, you've given a certificate. In the normal course, you would rely on the cert to say that if you were certified unfit from Monday to Friday, normally you're free to return from Saturday or Monday, the following Monday. But in this setting, I think it's reasonable for an employer only in these circumstances to say, I don't just want to rely on the cert to say you were unfit and therefore you're now fit thereafter. I want you to get proactively seek a certificate from your doctor to confirm your fitness after the certain date. And if they don't want to do that, or if they refuse to do that, and bearing in mind it's 50 or 60 quid a pop to go to a doctor to get these certs, if you want, as an employer, want that cert, get them referred to your own company doctor to give a certificate confirming fitness to return.
Look, I think it's fair to say most people, when you walk around, Dublin or elsewhere, most people are on message in terms of wearing face masks and social distancing, and people are getting the message out there, but some people aren't still. And there are, you do still see instances of non-compliance, whether it be by omission or it's intentional, and they're kind of protesting against it. But the workplace, can we compel employees to wear PPE and social distance, but mostly PPE?
I think it's a pretty heavy hand. It's almost going back to the master servant relationship, where the employer gets to dictate so severely how work is performed. And again, in the normal course, I would say, save for exceptional reasons, food preparation or specific health and safety considerations around the subject matter of the work, you might say, okay, well, it's reasonable for the employer in those circumstances to require a face mask. So in normal circumstances, you'd say, no, it's excessive. But given where we are now, and I've advised on this in the last 2 weeks, and we've got serious pushback. It's in a unionized employment. We've had pushback from the union and from worker representatives saying, this isn't a shop. This isn't one of the other prescribed locations. And bearing in mind now that, months ago, there was a discussion around face masks and queries around their efficacy. In last month, government expanded the guidelines and legal requirement for mask wearing beyond what was previously just transport and shops. And now it includes shopping centres, spas, bookmakers, nail parlours, tattoo parlours. So there has been a move towards expanding the requirement to wear face masks, but government hasn't gone so far as to say that every employer should. So now it's back on the employer then to decide, as part of their risk assessment, this COVID-specific risk assessment, does the employer decide what I decided back in March or April if I opened then, or what do I decide now around the safety to reopen business and perhaps compromised in relation to 2 meter social distancing? Am I now willing to adopt that heavier hand and say, I'm going to require everyone to wear a mask, failing which you could be disciplined? And I advised in that case recently, because there were issues, various pinch points where 2 meters wasn't possible, and they've imposed it. I think it's a reasonable request of employees. Again, it's not indefinite. It's not like this is going to be forever. But given the circumstances, it's a reasonable request.
Okay, thanks, Ronnie. And look, we're coming up to the 45 minutes mark, so I think it's probably time to end our discussion and moved on to Q&A. And look, clearly, I'm harassed of information to try and assimilate as a manager or a business owner on the employment side. And obviously, on Judith's side, key thing is I'm taking away anyway is certainly the financial information and keeping a handle on the financial position of the company almost on a weekly basis if the trading environment is challenged. So look, thanks both for your contributions. We might take some Q&A then from the Q&A list, and I'm seeing the first I'm seeing here is from Siobhan Brady. If a decision is made to put a company into insolvent liquidation, is it possible for the directors to incorporate a new company and start over? Perhaps, Judith, that's one for yourself.
Yeah, it's a great question, and I suppose it's somewhat of a bit of a ray of light in what is otherwise a gloomy situation. The answer is yes. In principle, there's nothing to prevent this, but it has to be done correctly, and I would say it's probably something that should be done with the benefit of legal advice. There's going to be certain conditions that have to be met if the director's new company wishes to, or indeed the directors themselves, wish to acquire the assets from the liquidator. And equally, if the liquidator is concerned regarding what the directors did with the insolvent company, or that assets or cash may have been stripped from the company, or any other steps may have been taken to devalue the assets, then it could present issues for the directors. I have a case at the moment where the directors of the insolvent company had made a personal loan to the company, and the company in turn had used that money to acquire fixtures and fittings for the business. Prior to the liquidation, the directors transferred the fixtures and fittings to a new company and without any consideration. And clearly that is not permissible, and it's going to be something of huge concern to a liquidator. You know, a personal loan being repaid in that way is just going to be really problematic. But, you know, as I've said, properly advised and where the directors have fulfilled their duties to the insolvent company and to its creditors, of course, then it ought to be possible to start afresh.
Okay, very good. Ronnie, I think we've one for you. It's from Susanna Doyle, and the question is, can I change my sick leave policy to reduce the amount of pay to employees, particularly where I have a large number of people who can't come to work?
Again, we're looking at it's not hedging, but it's just acknowledging that things are quite unusual at the moment with COVID. So I think the answer is possibly. I think you'd need to look at where the sick leave entitlements sit. You know, if there's a specific contractual entitlement sitting in the contract, for instance, and you know, some folks might have a 3-month or more senior management might have a 6-month period locked into the contract for sick pay. And sometimes then thereafter going to permanent health insurance would kick in. And if that's where it sits, then it forms part of the terms and conditions of employment and part of the contract and would require consent in the normal circumstances. If it sits outside the contract, in a policy, for instance, and often a sick pay policy will be drafted well, because it might provide that this doesn't form part of your contract of employment, and would also provide that the employer reserves the right to discontinue the sick pay or to change the amount on offer, to alter the nature of the scheme. That's obviously far easier for the employer to do then in saying, okay, we're now varying our sick pay policy. Whether they explain why is a separate matter, but it's legally more, it's easier to vary a sick pay policy that isn't locked in and contractual. Just because it's contractual doesn't mean that some businesses are not making changes, just the same as just because your pay is contractual. Some businesses are making reductions in pay. You know, unilateral pay cuts, unilateral variations to contract, like reducing a sick pay entitlement. Sometimes those are measures being taken rather than facing the alternative of affecting redundancies. And I think the key then is consultation. Because even though technically it'll be a legal breach, unless you either have to have contractual authority or consent. If you don't have contractual authority, if you don't get consent, then you're open to legal challenge. The most obvious being a payment of wages claim. But we think that there's some circumstances, you know, if there's empathy, or if there's sympathy shown for an employer who says, I consulted with staff, tried to get their consent, shared the rationale, shared the explanation. This is a genuine measure, not an effort to, or a measure to almost profit from this crisis, but a genuine measure to keep the head above water. You know, in those circumstances, it's, you know, again, I'm not giving carte blanche, but there may well be situations where a technical breach does not result in a sanction. So I think the question is it contractual? And then what do you do? Consult, and then you may still take a commercial decision. If it's not contractual, much easier.
Okay, thanks, Ronnie. I think there's just one last question here that I see, and one for you, Ronnie, possibly. It's from John McIlerney, and he asks, is there an agency you can contact to check that your employer, sports club, are in compliance with the back to work suggestions?
There is an agency that you can contact for guidance, which is the HSA. The HSA will inspect. I don't think they'll do it on request. So if you say, as an employer, we've done loads of good stuff, we'd like you to come and check for us. That case I mentioned, real life case at a factory, the unionized employer with the masks, that factory has been inspected 3 times since March, since the lockdown. A couple of times independently of any sort of request being made, but the 3rd time more recently was effectively the union or the employee reps who are unhappy with the face masks. I'm going to say dobbing them in, but it's saying to the HSA, oh, we're concerned about certain compliance. Now they've come through it with flying colours, so the HSA will go out and inspect the premises, but usually it's not done in a it is done in a cooperative way. They're trying to bring people along. But it's not like you can contact them and say, can you come out and inspect? but you can get lots of information from them. They are very helpful because they don't want to prosecute. They want to facilitate and support people to become compliant. Other than that, I think it's an external health and safety consultant, of which, unsurprisingly, there are a whole raft of consultants that have recently come into being, because obviously health and safety is now way more crucial to those businesses who are reopening and the survival of business, because this is a movable feast. Some folks don't have the resources or aren't big enough to engage a third party. But for those who have concerns in relation to the changing landscape, or for those who have the resources, you should really be getting an external third party to make sure that whatever concerns you have around, the appropriate measures you put in, and whether you're ticking the boxes for being compliant, particularly given those criminal sanctions that we talked about, I think it's a measure certainly worth taking.
Okay, thanks, Ronnie. Look, I think we'll leave it there. Look, firstly, thank you to the TBA for inviting us to present this discussion. And we certainly hope for the members who are logged on this afternoon that you found it useful. And we've helped to highlight some of the principal kind of legal considerations which business owners need to take into account in this current environment. So thanks again for attending and listening, and keep safe, and I'll hand it back to Michael.
Thank you, William, and thank you also, Judith and Ronnie, for a really fascinating and extremely relevant discussion. It's been a privilege to have you all on, sharing your expertise with the TBA community today. Thank you also to everyone who tuned in. We will be circulating further information and links provided by Mason Hayes & Curran in our follow-up email, which will come out in the next day or two, as well as a survey that I ask that you fill in so that we can continue to bring you content relevant to you in your professional development. Today's webinar will be available on the TBA's website within the next couple of days, and that website is www.tba.ie, and that's really the best place to stay up to date with the group, as well as to find previous recordings and resources. And I'll just throw that link up on the screen for you as well now. We also have a LinkedIn page, and I would encourage you to join that as well, so you can stay up to date with other great events such as today's. So on behalf of the TBA, as well as Trinity Development and Alumni, thank you very much for joining us. Stay safe, and we'll see you again very soon.